Right, good morning to again my wonderful year two law students. Happy Easter Monday. Today is Monday the 10th of April 2013. I hope you've had a wonderful Easter break so far. Weather's a little bit cold and, well, not cold really, but just a bit wet and damp, but nevertheless, quickly let's go through today's topic. So we're looking at economic loss and a little bit on negligent misstatement. So if we start off with economic loss is where the claimant suffers financial loss based on the negligence of another party. So there's clear evidence of either personal injury or damage to property that then results in the claimant losing out financially. So that's what economic loss is. Now, the difference is the definition in pure economic loss, which you cannot claim for. So pure economic loss is simply where the claimant suffers financial loss, but nevertheless it's not a result of the defendant's negligence, either causing them personal injury or damage to property. So that's the difference between economic loss, where there's injury or damage to property that causes personal financial loss, and pure economic loss, where there is financial loss to the claimant, but it's not caused by the defendant. A case to confirm the difference between the two types of losses, so economic loss and pure economic loss, is the case of Spartan Steel and Martin, where the claimant could naturally claim for foreseeable loss, but they couldn't claim for profits that they would have made had there not been damage to their property. So please have a look at all the cases to go with economic loss and pure economic loss. So that's a quick summary. Again, don't forget to refer to the textbook and make sure that you can identify other case law that go with economic loss and pure economic loss. Now, if we move on to negligent misstatement, now the definition is simply where the defendant has specialist knowledge and skill and they make a statement that ends up being incorrect, and that causes the claimant financial loss. Right, so in terms of negligent misstatement, if you are going to prove negligent misstatement, then you essentially, the original action available to you was in the tort of deceit. Now, in the tort of deceit, the claimant would have to prove that the defendant was reckless and deliberately told a lie which caused them financial loss. So the tort of deceit wasn't very easy to prove, but now you can use the common law principle under Headley, Byrne and Heller. So under Headley, Byrne and Heller, all you would have to prove is that the defendant had specialist skill and knowledge. The defendant knew that the claimant would rely on the information they were giving, and in fact the claimant did rely on that information. Now, in terms of, and again, just check the time, I've got my glasses on. So in terms of the defendant having specialist knowledge, that's been interpreted quite widely, because there have been cases, or at least one case, which I shall refer to in a moment, where the maker of the statement that led to financial loss wasn't an expert. In fact, they were just a friend of the claimant. And the case I'm thinking of here is Chowdhury and Prabhakar, where the defendant gave friendly advice about the suitability or roadworthiness of a car, and that information turned out to be wrong, and the claimant lost money, and the courts were willing to allow a claim to be made. So as I say, this is just a quick short video on economic loss and negligent misstatement, and I think the key cases for economic loss is Steele and Martin, and the key case for negligent misstatement will be Headley, Byrne and Heller. Right, so don't forget, keep revising. Please keep working on the work I set on Microsoft Teams, and all being well, hopefully I'll see you tomorrow on a more dry and hopefully slightly sunnier day. enjoy Easter Monday, and yes, hopefully see you all on the 17th of April. But look out for another video, all being well, tomorrow. Good morning.